how to avoid them. My name is Julie Dorr, and I will be your moderator for today's event. Our presentation will last approximately 40 minutes with the remaining time available for your questions. If during the presentation you have any questions, feel free to type them in a designated section that's marked questions over on the right-hand side, and I'll be happy to actually hold those, and then we'll answer them at the end of the webinar. Earlier this morning, we emailed you a link to a copy of our presentation. If you haven't received it, feel free to email me right now at julie@enlightenbiz.com. I've also included that email address in the chat area so that you've got it and you can just copy and paste it. And I'll send you that document during the presentation so you'll have it. Before we get started, please also note that this webinar and all the accompanying materials are protected by copyright and that the entire conference is being recorded. This presentation provides general information only and does not constitute legal advice. We recommend that you consult with your legal counsel to address your specific situation. So Linda, I'm noticing the slides aren't moving, and I'm sensing that we might have an issue with that. So I'm going to take over the presentation.
I'm moving them, so I don't know what the problem is.
Okay, well let me take over the presentation while I'm introducing our wonderful speakers today. And you've already heard from Linda Duffy. Linda is the president of Ethos Human Capital Solutions, and she works with Ethos Human Capital Solutions, and she is works with business owners and executives and provides strategic human resources direction, develops leadership talent, and increases organizational effectiveness. And then we're going to be moving on to Marla, who's going to start us off here. There we go. I've got Marla's bio up there. Marla is an attorney with the law firm Merhab Robinson, Jackson & Clarkson, where she's a partner and head of the firm's transactional department. She primarily practices in the areas of corporate, mergers and acquisitions, real estate, finance, and employment law. So Marla, I understand we're going to start with you. And again, I apologize for the technical problems. Believe it or not, we did actually test this out right before we got started. And lo and behold, it still doesn't work. So my apologies. Marla, you want to get us started?
I will. But before I start with the agenda on your screen, I want to describe the employment audit process that we go through at our firm, and I'm sure Linda will do the same with her firm when she starts her portion of the program. So what we do is we review everything, every employment document that the employer is currently using. I call it from the application to the exit interview form and everything in between. So we ask the employer to send us all their employment documents that they're using, including the handbook, and then we review them for compliance with state and federal law. If they don't have a document that we recommend or that they are required by law to have, we provide that during the audit process. And then we review and revise if they have a handbook, the handbook, and if they don't, we prepare a handbook. So that's what our audit process is. Our audit process does not include an analysis of the exempt versus non-exempt. That's an add-on to our audit process, but it is something that we do engage in. So when we're doing that process is when these mistakes occur or are found, and that's what we're going to talk about today. So here, the first agenda are the items that I'm going to be covering, and as you can see, even my portion is quite a lot. So I'm not going to go into detail, a lot of detail about each one of these areas of the law. I'm going to talk specifically to the errors that are made in these areas. And then I'll give you some dates when we will be covering some of these in later webinars in that detail, and also some that we've already covered we can provide later. The second agenda is what Linda will be covering, and again, you can see it's quite a bit. So let's get on to the mistakes that we find. And they are in no particular order, although I will identify the ones that I think I see the most often. So the first is improperly running background checks and not complying with the law in this area. And the law here, I will give you the law for those of you who are legal geeks like me. It's the California Investigative Consumer Reporting Agencies Act, and it can be found at Civil Code 1786, that's SEC. And it requires certain disclosures and pre-authorizations. And it requires that applicants, candidates be offered a copy. There are some other requirements that have to be complied with. So your documentation is really important here. And what we find is that the documentation either doesn't exist or it's not in compliance with the law. So that's the error that we find here. The second is improperly running credit checks. And of course, this has really changed in the last couple of years because effective January 1, 2012, the law changed to prohibit credit checks except in specific circumstances related to certain positions. And primarily that's management positions and people who are touching money. It's actually enumerated in the Act, and again, for the legal geeks, it's the California Consumer Credit Reporting Agency Act, and it's at Civil Code 1785 at SEC. What we see here again is either improper forms or no forms, not providing the candidate with a copy. With respect to the managerial positions, it's not defined in the Act. It's actually defined in the Labor Code, and that's Section 1024.5. And the definition is the same as what you would find in the Industrial Wage Commission Order number 4, the employee who qualifies for the executive exemption under that Wage Order 4. So the next mistake we see is not engaging in the interactive process. And again, this is fairly new because most employers weren't required to engage in the interactive process if they didn't fall under the Americans with Disabilities Act and had 20 or more employees. But now FEHA requires an interactive process, the Fair Employment and Housing Act at Government Code Section 12926.1. And this area is just fraught with trouble because it's not well defined in the law. It is very clear that if you know an employee has a disability or you perceive that the employee has a disability, that you must engage in this interactive process. And I would caution everyone to use an attorney during this process because it is what I would call the litigation du jour. It's the plaintiff's bar, the attorneys who represent employees' favorite lawsuit right now. It's not sexual harassment anymore. We see these more than anything else. And that's because reasonableness is not a defined term. What's reasonable for Coca-Cola may not be reasonable for you or for your company. So because it's not defined, there's always a question. Was it reasonable? Let's let a judge or a jury decide. So the plaintiff's attorneys really like to bring these cases. So we want to do everything we can to make sure that the documentation of the process is correct if we have to go in and defend a claim. So, and engaging in the process is the first step. The process itself is a second step. So I, again, would encourage you to seek the help of counsel or a good HR consultant like Linda if you're going to have to go through this process. The next error or mistake would be no leave of absence forms or processes. And this is probably the highest degree of difficulty, and it connects kind of with the prior one as well, in the HR world. This, leaves of absence are just so convoluted, and we have so many. I mean, pregnancy disability leave, FMLA, CFRA, sick leave, vacation, kin care leave. That's just some. That's not even all of them. So there's so many different types of leaves that we just see so many errors here. We should be advising employees that they should put their request for leaves in writing, and then we should be enforcing that. But even if they don't request, there's many of these leaves that require you to notify them, by the way, this leave is available for you. Do you want to use it? And then questioning them on returning the response to that. So there's forms that we see that are wrong here, and then there's processes that we see are not being followed or not put in place here. Just a common error that I see all the time here is with pregnancy disability leave. Employees believe that if they're pregnant, they get leave. That's not the test. That's not what the law says. You get leave when you're disabled and you're pregnant. A normal pregnancy, the disability is usually around 6 weeks. The C-section pregnancy disability is about 8. Of course, there's pregnancies with complications. It could be much more than that. But you don't just get leave because you're pregnant. A doctor has to certify that you're disabled. That's a really common error and mistake we see all the time because the employees believe it so strongly, and when they talk to the HR directors, they tell them that's the way it is. It's not. Okay, so let's move on to the next mistake. And this would be the one I would classify as the most common mistake I see when we do audits all the time, and that's misclassifying employees as independent contractors. Most of the employers that I work with don't do this intentionally. They just don't know or understand the law. I just, as a matter of fact, had this conversation last night. I met with a client who asked me to review a contract for an employee, but it was written as an independent contractor agreement. And the employee was representing that she was running another business and was going to be an independent contractor, and the employer was agreeing. He says, well, we agree. So it doesn't matter. It doesn't matter what the employer and the employee state in their agreement, in their written agreement. The EDD or the IRS will determine whether or not the employee is truly an independent, or the worker, excuse me, is truly an independent contractor or an employee. And I will tell you that it's very rare that they meet the independent contractor test. The common law test, there's about 20 that the IRS looks at. If anybody's interested in a memo on it, I can shoot you a memo that we put out to all of our clients and potential clients. But it all revolves around control and whether this person has a capital at risk in running their own business. If they're coming to your place of employment from 8 to 5 and using all of your tools and instrumentalities, they're likely an employee and not an independent contractor. What should be standing out to everyone's eyes in looking at this slide is that there is potential personal liability here to the IRS for misclassification. If taxes aren't paid by the employee, they can come after the employer individually, an individual, whoever was responsible for payroll, personally, not just a company. And that's unique in the employment world, so it should frighten everybody. The next mistake would be no timekeeping or incorrect timekeeping. There's two. So one of those, no timekeeping, I'll speak to later on classification of employees, and the other would be incorrect timekeeping, not showing beginning and ending of shifts, as well as meal periods, starts and stops. Now, if you have a bell that rings and you can prove that you have a bell that rings in a plant or a factory, I have a lot of clients that do that from 12 to 12:30 or from 12:30 to 1 for lunch, then you don't have to have that time in, time out, but you have to have some way of proving that you have that bell. And it would be better that you did have on each time record that that's when the bell rang. The rules for this can be found in the wage orders as well, Section 7. And we will be doing a webinar on record keeping and record retention on April 24th because timekeeping leads right into that. It's more than just the timekeeping records. It's also the paycheck records as well. And this is the first thing a plaintiff's attorney who represents employees is going to ask for, no matter what the claim is, because it's very often where they find overtime mistakes and timekeeping and record keeping mistakes. So April 24th will be that webinar. So the next mistake would be what I would classify as the second most common mistake. And again, like the classification, improper classification as an independent contractor versus an employee, most employers don't make this mistake on purpose. Some do, but most don't. The law is very difficult to understand, and it's misunderstood very often. Most employers feel if they pay an employee a salary, they've made them exempt from overtime, and that's just not the test. It's one of the tests. There are actually 3 exemptions to overtime and to make an employee exempt from overtime, and that is the administrative, professional, and executive. To break them down for purposes of our discussion today, to make it as simple as possible, the professional one is the easiest one to get rid of. You have to have a license in law or medicine, dentistry, optometry, architecture, engineering, teaching, or accounting, or learned or artistic profession, which is a very small, often not made exemption. So that's an easy one to disqualify somebody from if they don't have that license. The second would be the executive, and it's fairly easy as well. You have to be managing 2 or more people with the authority to hire, fire, promote, demote. If you don't have that authority, your opinion has to take great weight and participate with others in that authority. But you do have to be managing, and you have to be managing 51% or more of the time, not doing activities that are non-managerial 51% or more of the time. And that very often knocks out many employees from that exemption. The most difficult exemption is the administrative exemption, and that is somebody who is participating in making business policy. And there's some cases right now up with the California Supreme Court that hopefully will give us some better definitions here because it's very murky right now. All 3 must have that salary component, 2 times the minimum wage, and all 3 must customarily and regularly exercise discretion and independent judgment. That's the language straight out of the law, which is the industrial wage orders for those legal geek friends of mine. And it's again, not well-defined language. You should think of authority and power and someone who doesn't have to have direction from someone else. The best example I can give is a bookkeeper. If you have a bookkeeper who has authority to decide who gets paid and doesn't get paid, whether to increase a line of credit or not increase a line of credit without having to go to the boss, then you've got someone who's probably exempt administratively. Most don't, and so most don't fall under that exemption. The next mistake we see is improper deductions from employees who are exempt, who've made one of those exempt qualifications we just discussed, from their pay. And the reason that's a mistake is once you do that, you convert that employee from an exempt employee to a non-exempt employee, and now they're entitled to overtime. And now we have a problem because most employers who have classified someone as exempt, whether correctly or not, don't require them to keep time records because they're exempt. They're exempt from overtime. But if you've changed them from exempt to non-exempt by deducting for time missed, now you've got someone who you do need time records for, and you are the employer, as the employer, are required to have them, and you don't have them. So the employee gets to create them, and they're deemed to be the truth unless you can prove otherwise, which is difficult unless you're using cameras or computers that are logging in and logging out for everyone. The law here in California is you cannot deduct from an exempt person's pay if they've worked 1 day of a defined work week. They are entitled to be paid for the whole week. You can deduct from their sick time and you can deduct from their vacation, but you cannot deduct from their wage, from their salary. The federal law is a little different. There are some listed exemptions, but in California you cannot. And I get this call all the time from employers who want to do that. And the reason the law is that way is because exempt employees are expected to work more than 40 hours when necessary, and so when they work less, it's okay as well. So my employers often ask, well, what do I do? You discipline. You discipline the employee who is not working, and then possibly terminate if that person is not providing the time that they should be providing. So now I'm going to turn it over to Linda.
Thanks, Marla. That was great, and it's a perfect segue into talking about vacation policies. So hi, everybody. Welcome today. And again, sorry about the technical glitch. Julie and I go through it every single time, and one of these days, hopefully, we'll get it to work correctly. The first mistake we see a lot on audits is having to do with vacation policies, and there's a few different types of problems that we see. So first of all, everyone should know that there's no requirement in the state of California to provide vacation time or PTO or sick or holiday or anything for that matter. But if you do, then there's certain rules that you need to live by. So the seminal case in this area is from 1982. A lot of people have probably heard about it, Flaquez versus Plastic Dress-Up. And basically, that's the case that sort of threw out all the rules having to do with how you need to manage vacation. So for example, the DLSA says that vacation is earned as labor is performed. So you can accrue it as time goes on. So for every day or week or month or however you want to look at it, you get a certain number of vacation hours. You cannot, however, have a use it or lose it policy. And a lot of my clients say, well, I want them to use it in the year that I give it to them. Well, that's great that you want to do that, but unfortunately, there's, in Flaquez and also in subsequent court cases, it's been made very clear you cannot have a policy written that way. You can, however, put a reasonable, and that's the phrase, reasonable cap on vacation accrual. And courts have suggested that can be no less than about 1.5 times the annual accrual rate. So let's say that your accrual rate is 2 weeks per year. Then you could cap somebody at 3 weeks. That would be considered reasonable. You cannot cap somebody at 2 weeks because obviously you have a use it or lose it policy. And you could not cap them at like 2 weeks and 1 minute or something like that because you're just trying to get around the use it or lose it. So court cases have said somewhere around 1.5 times is probably reasonable. So that's what I suggest to my clients. So as the accrual goes up, you increase it proportionately. So a lot of times what I'll also see as a problem is people put a cap on it, but they put a cap on it at a flat number. And subsequently, as the accrual goes up from 2 weeks to 3 weeks to 4 weeks of length of service, or however you do it, they're, again, falling below that 1.5 threshold. So you want to just review your vacation policy for that. The other area is if you combine vacation and sick together to make PTO or any time off, and you go with a paid time off policy as opposed to splitting it out, in essence, now everything is subject to the same rules that your vacation policy is subject to. So you still have the use it or lose it. You have the accrual. It also has to be paid out upon termination. And so that's what I counsel my clients about is here are the offsets. It's so much easier to manage, in my opinion, when you have a PTO policy as opposed to having them separate. It's a lot easier to manage exempt people's time off. It's a lot easier just from an administrative standpoint. And you also avoid all of the year-end gains. Like a lot of my clients will give 5 days of sick day during the year, that they lose it at the end of the year, which is perfectly acceptable under sick pay policy laws. But once you combine it with PTO, now it doesn't matter. You're going to continue to accrue it, as we talked about earlier. But if you have a sick pay policy, then people know they're going to lose it at the end of December. Guess what happens in December? Everybody says, oh, I've got an extra day. I'll take it off so I can do my Christmas shopping or whatever. So you just want to be aware of that. But the flip side of that point is it now is an accrued liability on your books. If somebody leaves the company, you now are required to pay the sick time because it's wrapped up with the PTO time. Whereas if they were separate, you would not have to pay out the sick time. So those are some rules on that. The other thing that sometimes comes up is, can you deduct advanced vacation? And the answer is no. In California, you know, we're really limited in any kind of deductions we can make out of a final paycheck, and we cannot sort of recover any sort of advanced vacation we might have given an employee. So proceed there with your own risk. It does happen. Sometimes that's the easier option, especially maybe you have a shutdown around the holidays. People just started. You want to go ahead and give them some advance vacation time against their accrual, but you do run the risk that you are going to have to seek remedies other than deducting it from the final paycheck. Holiday pay, as I mentioned, there's no requirement to give holiday pay, but if you are, you want to just consider a couple different things. First of all, there's no requirement to pay overtime if an employee works on a holiday. Some companies do have that policy where they'll say if somebody works on a holiday, we're going to pay them time and a half for the hours worked in addition to their 8 hours of holiday pay. That's fine. You can do that, but there's no requirement to do that. You do want to, in your holiday pay policy, define what constitutes time worked. So if I work, you know, if I work 40 hours and then if I work 40 hours and one of those days is a holiday, is it time worked, or am I going to get paid 40 regular hours and 8 hours of holiday? How does that work? For some companies, you just work on a holiday and you do the short straw. So you have to sort of figure out how you want to handle that. Another area that seems to come up a lot right now for some reason is about floating holidays. So this is actually one of my pet peeves. Floating holidays drive me crazy because they really are vacation time if the employee has the option of when to use them. So my warning to my clients is don't have floating holidays where the employee can opt to have it. Don't have like, oh, we give them their birthday off. They can take it whenever they want to during the year. It's really been a vacation day, and it needs to be subject to the same rules we talked about on the prior slide. Now, what you can do is some of my clients want to have floating holidays because they don't want to have a set schedule every year. That's perfectly fine. So when I write a handbook for them or we write a holiday pay policy, we'll say, okay, the company generally observes, you know, let's say 8 paid holidays during the year. These 6 are, you know, pretty standard. You know, you've got Christmas and New Year's and 4th of July or whatever. And then we observe 2 floating holidays that the company will designate at the beginning of each year. Those are great policies to have because what happens in cases like when July 4th falls on a Thursday, maybe you want to have a 4-day shutdown and use one of those days on July 5th, or depending on where Christmas falls, something like that. So those are great, but don't have policies, in my opinion, where the employee gets to choose when to use those floating holidays. Okay, another one to watch out for is comp time or compensatory time off. Technically it's legal, but I have to say it's a really bad practice, and I discourage everyone from using it because very few companies get it right, and there's better ways, in my opinion, to handle it. So essentially how a lot of companies will use comp time policies is to say, oh, you know what, this person works on Saturday, so go ahead and take, you know, Wednesday off next week. Okay, that technically is not legal. For comp time, you have to take the time off during same work week, and it still has to be paid at time and a half. So let's say you have an example where an employee works 48 hours in a week, and then the employer wants to give a day off the next week to make up for it. Okay, first of all, it's illegal. If you gave it during the same week, let's say it was really front-loaded and you worked 4 12-hour days or something like that, you would have to give the time off during that week at the regular overtime rate, whether it's double time or overtime. So potentially you could say, hey, you know what, you worked 6 hours of overtime on Monday, you know, you could have them then take 9 hours off sometime during the rest of the week. It just doesn't seem to me to be a great way of handling it. The better way to handle it, in my opinion, is to use makeup time. And in California, they finally caught up with like reality of years ago and put in a law that says you can have makeup time. Now, there are specific rules around that. We're not going to get into details, but the short version is the employee has to be the one that requests it. It still has to be done during the same week. But this is perfect for the usual things that come up where an employee says, you know what, I've got a doctor's appointment. I need to leave a couple hours early on Wednesday. Can I make up the time? And if you as the employer want to allow them to do that, they should fill out a form to say, I want to make up the time off on Wednesday. Let's say I'm going to leave at 3 o'clock and I work till 5 normally. I'm going to make up those 2 hours by working late on Tuesday. Well, normally they just work late on Tuesday, and if you don't have a makeup form in your payroll file to back this up, you'd be paying them 2 hours of overtime. But under makeup time law, if they request it and you approve it, and you don't go over 11 hours in a day, you do not have to pay overtime for those 2 hours on Tuesday. But again, the makeup time has to be done during the same work week in order to avoid that. Okay? The last thing on this is sometimes I have employers, and this goes back to what Marla was saying about exempt status. The whole point of exempt status is it doesn't matter if it takes 1 day, 1 hour, 1 minute to get your job done, or if you're working 60 hours or 100 hours in a week. It does not matter. You get paid a flat salary. And every once in a while I have a client that says to me, oh, you know what, we have this, let's say, outside salesperson that's been traveling a lot, and you know they haven't been home the last 3 weekends with their family, so we're going to give them comp time and let them take some time off. Okay. My only caution is this: you can give them time off all you want to, because again, they're salaried. Never do it in direct proportion to the time that they're working sort of overtime. So don't say, well, they worked this Saturday as overtime, so we're going to give them a day off next week where it's hour for hour. Bonus them, just give them time off because they can take whatever they want to. You can do it a lot of different ways, but don't make it match hour for hour or based on time, because you're going to get into a potential situation where you're going to invalidate their exempt status. Okay, I-9 forms is probably hands down the #1 mistake I see on audits. I agree with Marla, the misclassifications are big issues as well, but I have yet, in now 7 years of having my business, gone into a company and done an audit where the I-9 forms were correct. Not a single time. Sometimes they're better than others, but for the most part, they are just a hot mess, to be honest. So first of all, everyone should be using the new form that came out just about a year ago. So if you haven't, you want to go ahead and download that form and make sure that you've been using it on all the forms since, or all the people hired since last March 8th. Or I think it was a requirement in May. Here are some of the mistakes I see. A lot of times they're just incomplete. They never get filled out at all, or they're just missing information. A lot of times the hire date on the form is missing. It's still in the blank toward the bottom of the form. You need to make sure that's in there. The employer has to sign it. A lot of times we see wrong documents where they put them in the wrong spot. They just don't have the right documents. They have something in column A and then something in column C. They put too much information on the form, whether it's filling out all 3 of these sections on the picture I have there, or maybe they just write extraneous information. Like the other day I was doing an audit and somebody had written notes about a direct deposit form at the top of the form. Don't do that. These forms are really, if you ever get audited, and I've been through an audit on this before, they are so nitpicky about every little thing. So if you look at the picture down at the bottom, this for whatever reason seems to be confusing to people, so I just wanted to point it out. The way this is set up for the I-9 form is you have to prove your identity and your eligibility to work in the United States. If there is a document that comes off of List A and there's an attachment that spells this out, like a passport, for example, if I have a U.S. passport that shows that I'm a U.S. citizen, I have the right to work in the United States, and it has my picture and my name in it, has my identity, all you need to do is fill out on fill out list A. If you don't have something like that and you need 2 documents, for example, something common would be a driver's license to establish your identity and then a Social Security card to establish employment authorization, then you fill out B and C. So it's a little bit confusing on the forms. They've tried to make it a little clearer. And what you're going to do is put the document title, guess what, in the space where it says document title. And I say that sarcastically, but I see this miscompleted all the time where people just write the information in and don't pay attention to where it goes. Or I was looking at forms the other day where they'd written in like the Social Security number just sort of loose somewhere on the form, and they put the Social Security number in, but they don't fill out the rest of the information. So you want to take some time to make sure you're actually doing this completely, because this is not a situation where you just get dinged per form. They will actually ding you for every single mistake on the form, and it adds up really quickly. Postings. There are so many different postings, and I'd love to tell you I could sit here and rattle them all off, but unfortunately there are both federal and state, and sometimes even municipality required postings. So everyone's going to be subject to certain postings like EEO and the FLSA. If you have 50 or more employees, you also have to post things like FMLA and CFRA. It could be industry specific. For example, if you work in agriculture, there's something called the Migrant and Seasonal Agricultural Worker Protection Act. Okay, I had to write that out because I've never even heard of it before. I don't have any employers in agriculture. That's a specific required posting for that industry. There's also California-specific things like CalOSHA, for example, and some of the anti-harassment and other things that we have in California. And then San Francisco, on top of it, has some specific, city postings that are required. So it's really important that you go through and you make sure you have all your postings. To me, the easiest way of doing that is to go online to one of these companies that actually sells them all put together. There's many of them out there. You can Google it, and you can just buy the required posters. You want to make sure, though, that you're buying something that's California compliant. So when you put it up, it has all the federal and the California compliant ones, and you want to make sure they're up to date. Now, for example, minimum wage goes up July 1st. That means all of the posters are going to have to be changed. Okay? So unless there's a space, and a lot of them leave a space where you can write it in yourself, just know that all of your posters have to be updated come July 1st with the new minimum wage. The other thing, the big mistake I see with posting, sometimes people will go out and they will buy those laminated posters, but they will forget that in California we have a specific requirement to hang the IWC order. So this is in industry classification, and if you don't know what it is, go out and just Google IWC order, and then you can figure out which one it applies to you. So like manufacturing, for example, is order number 1, and if you're in a manufacturing company, you need to go print out order number 1, you need to tack it up right next to all the rest of the postings. That is what spells out, as Marla pointed out, state exemption requirements, overtime, a whole bunch of different rules by industry order. On offer letters, one of the things that both Marla and I really recommend to companies is they use written offer letters when you're making a job offer. She'll call it an employment agreement. I would call it an offer letter. We spell out the terms of employment in there, right? We're going to hire you for this position. Maybe we say who you're going to report to in terms of a position title. We're going to tell you, are you exempt, non-exempt? We're going to tell you this is how much we're going to pay you. These are your benefits. We're going to spell out basically all the terms and conditions in there. We're also going to include all of the contingencies. And so I always look to make sure that my clients are spelling out the contingencies. For example, is the offer contingent upon successfully passing a background check or a drug test or a pre-placement physical or any of those things? You need to be careful about how you word those, but it's good to include all of those contingencies up front so people understand that you may withdraw the offer later if they fail something there. You always want to include at-will language in the offer letter, and that's a mistake that I frankly see a lot. I'm so sort of surprised if they'll put it in their handbook because they'll forget to put it in the offer letter. So you want to make sure that employees are recognizing from every single possible vantage point when they start work for you that you're an at-will employer. I include an expiration date in my offer letter to say that the offer is valid through a certain date. So you don't just leave it open-ended and let the employee decide if and when they, or candidate, if and when they want to accept the offer. You want to know right then, are they going to accept it, give them a few days to consider it, and give notice where they are. But make sure you put an expiration date. And then we have the employee not only sign it, but we actually have them initial each page of it, so we have a copy in their file from the get-go, so everybody's understanding what the terms and conditions of employment are. New hiring term forms. This is another one for me, probably in the top 5 on my list of mistakes I see during audits, where companies just don't have all the required new hire and term forms. In California, we actually have 7 required forms or pamphlets that have to be given to employees upon hire, and 8 if you're non-exempt because of the Wage Theft Act that went into place a couple years ago. We also have 2 term forms, plus you have to give everyone the final paycheck, plus you have a COBRA notification if you offer benefits when somebody leaves the company. So if you don't know what those forms are, you need to do some investigation. We actually, as Marla mentioned, how she does audits, we do the same thing, and we provide you those forms as part of the audit if you don't have them. What we do is recommend you have checklists when you're going through a new hire and termination process, so you always, always, always do everything the same way, and that you make sure you're capturing all of the information. So there's, in addition to the required forms, also some recommended forms. For example, like we suggest to our clients that they have a trade secret or a proprietary information agreement. Some companies want to use an arbitration agreement. There's things that are easier to get them to sign up front when they want a job than later on after they're already employed. The last thing we're going to talk about just in terms of mistakes is handbooks. A lot of times we'll see handbooks that are just woefully outdated. You know, I'll ask a client as I'm talking to a potential new client, and maybe we're discussing doing an audit or a handbook or both for them, and I'll say, when was the last time you looked at your handbook? And they'll say, oh, it was, 8 years ago or something. Sometimes I'll ask them, where did you get your handbook, or did you have an attorney or a consultant do your handbook? And they'll say, oh, we downloaded it online, or my friend used to work for Coca-Cola and we took theirs, or I've heard all sorts of strange stories. So you want to make sure that if you do have a handbook, first and foremost, that it's California compliant. So a lot of these, I was just looking online last week at an HR online company. It's based in California, but it's not even California compliant. Like if you went and downloaded their new hire checklist or their new hire forms or their handbook, they have generic forms. They don't even have all the requirements for California. So you want to make sure that you're California compliant, that it's up to date as much as possible, and you're not including wrong information or unnecessary information. Like I had another client that had fewer than 50 employees. They had taken a handbook from another resource, didn't realize they weren't subject to FMLA or CFRA, and yet put that benefit essentially out in the handbook for everybody to say, oh yeah, you can have, under these circumstances, you can have this leave of absence, and give them job protection and all sorts of stuff that they weren't entitled to. So you want to make sure that you're not, you're getting them from the right sources, let's say. Marla mentioned her process for doing audits. I'll quickly just mention mine, and then we'll go through some questions. When we go in, we've got actually a few different levels of audit. So we have a basic, what we call compliance audit, where we'll come in and look at sort of the basic things in the HR and payroll area, like a lot of wage and hour issues, looking at the forms, that kind of stuff. We have also what we call a best practices audit, which does include writing a handbook. And we sit down and we walk you through every single process in the HR department, from hiring to firing, everything in between. And so we can not only look for compliance, but also make some suggestions for best practices and how you might be able to improve a process. So little things like the floating holidays, as I mentioned. It's not illegal to offer floating holidays, but we want to make sure that you're doing it the right way, and then we would have suggestions. Well, maybe you want to do it this way instead, or streamline something, where we've gone in to find companies do all sorts of just crazy things around payroll, where they're sort of estimating hours up front and then spending, 2 days the next week reconciling payroll. And there's so much easier ways to do it. So we try to go through and look for best practices in addition to just the compliance issues. So with that, Julie, I'm going to turn it back over to you, and we'll take any questions that anybody has.
Marla, before we begin Q&A, did you want to add something too, just based on what Linda had covered?
I did. I just wanted to add that in 26 years of practice and doing audits for probably 20 of those, I have never gone into a company and not found a mistake, or at least one. So I wanted to point that out because I neglected to mention that. And then I just wanted to hammer home one of the points that Linda brought up, because I get employers all the time calling me about this and misunderstanding. With the I-9s, there are two types of penalties. There's the penalty for hiring someone who doesn't have the right to work in the United States, and then the second type of penalty, as Linda references, completing the form incorrectly. You may have the form and you may have put information on it, but if it's incorrect, there's another penalty. This actually happened to a company that my family owned about 15, 16 years ago, and the penalties were very, very steep. We did not have any workers who were not authorized to work in the United States, but the forms were all done incorrectly, and the penalties were in the tens of thousands of dollars.
Right.
So I just wanted to hammer that home.
Wow. Okay, good. Well, thank you very much, ladies. I think that definitely will help us kind of avoid those landmines that we might step on when we make some, or when we're looking actually at making some decisions in our HR departments. What we're going to do now is handle some Q&A here for the last 15 minutes or so. Again, the way you do that is there is a questions panel over on the right-hand side for most of you looking at your computers. All you do is click on that. You can type your question right in the open space below and hit return, and then I'll be able to read that aloud for either Linda or Marla to answer. So we're going to start first with the question from Margarita. She's basically asking about the, it was stated that in the state of California for an exempt salary employee, you are not able to deduct from their salary, but you can use their PTO time that they have accumulated. What happens if they have used all of their PTO time and they are still taking days off? Can you deduct that day that they didn't work?
No, you cannot. And let's talk about one of the comments that Linda made about best practices. My recommendation to my clients is, and employers that I speak to, is do not deduct for anything. Even with the PTO available, if it's just a day off, unless it's specifically asked as vacation time, the risk is just so high. Once you make an improper deduction, and you don't know until someone rules on that for you, you've converted that employee to a non-exempt employee, and they have the ability to bring a claim for overtime for 3 years if their agreement is oral, and if you have an offer letter or an employment agreement like we recommend, then it's 4 years back. So I definitely, for best practices, don't recommend any deductions. But no, you cannot. Once if you're deducting from their PTO, once you've exhausted it, you've exhausted it. If they've worked 1 day of the work week, they have to be paid the salary for that whole work week. And again, the second question, usually the follow-up question there is, well, what can I do about this person's abusing it? You need to discipline that person.
Okay, good.
Yeah, let me just jump on that, Marguerite. If you want to send me an email, we're going to do a webinar on the exempt status in June. So it's potential we'll touch more in detail on that. But we did this seminar, our webinar last year. I can send you a link to it. We put together a document specific about deductions from exempt employees' paychecks. So if you want to shoot me an email, I'm happy to send you that article over.
Okay, good. And the next few questions all deal with I-9s, and I believe we're covering that topic in September, I think. So I'm going to read these, and basically, if, we may not get into it as depth of response as we will cover, obviously, in our next the webinar that we'll handle with this topic. So again, here's for the I-9 forms. If the new hire gives you their Social Security number, what do you put in a document under List C of the form? And do you write the Social Security number on the number on the back of the I-9? Is there a confidentiality? Maybe what Margarita is getting at is there a confidentiality issue in using Social Security numbers on the I-9 forms?
No. In fact, it's a requirement if that's the document they're going to produce. So you write the document number in the section where it says document number, and you're going to write the document title is Social Security card. You're going to have to look on the card itself to see who the issuing authority is. So, for example, mine I think was Department of Human Services or something like that. I was doing this week with another client, and we had to get a magnifying glass, right, to look at the card, and it was Health, Education, and Welfare. So it depends on when the card was issued, who the issuing authority is, so don't just assume anything, right, and don't write USA because that's not the issuing authority. So actually you have to look and inspect the card and write the issuing authority, write the number in, and then on Social Security card there's no expiration date. The requirement is not just to take the number from somebody. The requirement is actually to inspect the document to make sure that they're valid. So this becomes an issue if you've got remote employees, for example, as this client I was with this week does. And so I was talking to her with alternatives about having a local manager inspect them and fill out the form, and you just verify it was filled out correctly or things like that. The I-9 form should not be kept in the employee file. We always recommend that you split those out separately and make an I-9 folder. So it's a 3-ring binder, and you put all of the I-9 forms in that and keep that locked up so no one has access to anything regarding their identity or their Social Security number.
Oh, good. All right, good advice. Leanne's also wondering is it required for I-9 compliance to view the original document, or can you view a copy from the employee? Is that okay, or do you have to view the original document?
Technically, it's supposed to be the original document. Again, that presents challenges, so I'm not going to say that I've always been 100% compliant in that myself. When we had like out-of-state employees, like salespeople working out of their homes or something like that, we'd usually have them, if they come out for an orientation or onboarding process, we'd ask them to bring the documents with them. But to get the forms filled out within the first 72 hours, if they weren't going to be on site, we'd ask them to make copies and then fax them or scan them or whatever to us. But technically, the requirement is to inspect the original document. Now, the other question that comes up a lot is about whether or not you should keep copies of the documents. And I don't remember if I asked Marla her opinion on this. Mine is strongly in favor of keeping copies, only because we have these issues where forms don't get filled out in a timely manner, and you don't want to have to hunt down the employee later and ask them to find their documents again. So if you do decide you want to keep copies of, say, the driver's license and the Social Security card, if those are the two documents, we actually take the copy and we staple it to the I-9 form and put it in the notebook. You don't have to retain those if you don't want to, but you can certainly do it. And I've just found that it helps to have those documents as backup in case you missed a line on the form and need to go back, like you audit yourself later, and then you go, oh, wow, we didn't fill out something, or we forgot to put the issuing authority. You have the document right there, a copy of it at least, that you can check.
Okay. And Marla, did you have any? Yeah. Okay. Good. Ginny's feeling like her I-9s are not in compliance, and she's wondering if you would recommend that you go back and redo all the forms for all the employees with the new forms, even those employees who've worked, longer term, say more than 10 years.
Right. No, actually you cannot do that. Okay. What you can do is audit the forms, and like what I did with my client this week, what you do is you put in a memo like to the folder. Let's say if you have them in a notebook, you actually write a memo to the notebook to say, hey, on this date, in this case, the memo reads something like, on this date, Linda Duffy, a consultant with, Ethos Human Capital Solutions, did an audit of the I-9 forms, some, errors and omissions were discovered and subsequently corrected. If it's something you can line through and initial and correct on the form, you're allowed to do that. Do not use whiteout, okay? If you can line through and correct it, you can do that. If you need to redo the document because it's just a hot mess, like some of these were, you then do a new document and you staple it to the old document and keep it in the notebook. Okay, so you never shred the original ones, you don't throw them out, and you are not allowed to just across the board go back to everybody and say, hey, everybody, we want to recertify you. You cannot do that, but you are allowed to correct mistakes. Okay,
good. Leanne's wondering if you could repeat what you said about the use it or lose it policy. Is that a California law only, or is it a federal law?
California law. Very specific to California. You cannot accrue vacation time and then tell them they're going to lose it like at the end of the year. You can put a cap and max out their accrual. So again, you could say, let's say your benefit is 2 weeks per year of service. You can't say, hey, we're going to give you 2 weeks, so you're going to accrue 2 weeks during the year, but you have to use it all by December. You can say, we're going to put a cap on your accrual at 3 weeks. So once you hit 120 hours, you no longer accrue any more time until you use some up and it drops below that maximum accrual rate. But California specifically says you cannot have a use it or lose it policy when it comes to vacation, or again, if you combine all of your time off into PTO, the same rules would apply.
Okay, good.
And I would just throw out for whoever asked that question, if you're doing business outside of California, most other states do allow it, which is why we see it so much as a mistake here, because employers who come here from out of state, they'll just bring their policies with them a lot of times. So if you are in another state, check, because it's not all, but most do.
Okay,
and then also,
good.
I'll just make sure that you're specific in your handbook. So some rules may only apply to your California-based employees if you want to do it that way, and just make sure that you have a separate handbook for them where it says very specifically that everybody else will lose it at the end of the year, and California will have this max accrual.
Okay, good. Thank you. Judy has an interesting question about payroll. If an employee asks for an advance, can she set up a promissory note and then deduct what that note says from their payroll?
Yes, if you have permission to deduct, you can, and you should set up a promissory note and get permission to deduct from each payroll until or unless the employee gets terminated. Once the employee is terminated, you cannot take anything more unless on that day the employee says, okay, it's okay to deduct X amount. You can't even ask. So yes, you should set up a promissory note. But if they get terminated, then you have to get in line with every other creditor and sue them for whatever it is that they owe you.
Okay, good. All right. And then Courtney just wanted some clarification. We were talking about the I-9s, and she's just wondering what the document number you're referring to. Is it, we were talking about that conversation on Social Security numbers. Is that the number located on the back of the SSC?
I'm sorry, I'm not understanding. You're asking what the form number is for the I-9 form?
Yeah, we were talking about the Social Security number. What's the document number you were referring to? Is it the Social Security number or the number located on the back of SSC?
Sorry, Julie, I'm not getting it all. The form number is I-9. It's Form I-9.
Okay.
That's what the form number is. The question I thought you asked earlier was, for privacy reasons, should the Social Security number be written somewhere on the back of the form?
Yeah, that was the question.
Yeah, my answer is no. It needs to be written actually in the form, in the space where it asks you for that number. Okay. So I put on the one slide, I just took a little screenshot of the one part where the employer goes through and inspects the documents and actually fills out the form. So it's Section 2 of the I-9 form, and that was the screenshot that I took, or the snapshot I took. So where it said List A or List B and List C. So a Social Security card is an employment authorization. It belongs under List C. And where it says document title, again, you write in Social Security card, issuing authority, whatever the authority was that issued, like Department of Health and Human Services, depending when it was. The document number is the Social Security number, and you would write it on that line.
Okay. And Courtney, if I didn't quite interpret your question the way you intended, by all means, feel free to email either Linda or Marla your question, and so they can answer that for you. This one is a common one that we often get asked. What documents should be kept in the employee files, and what should be kept in separate files? We talked about keeping Social Security cards separate for privacy reasons. Is there a hard, fast rule that you guys could give, or a recommendation that you would give to our audience?
Well, we actually recommend you split them out a few different ways. Marla, let me jump in and then jump on after me. And we're going to go through this in April at that webinar, so by all means, make sure you sign up for the April 24th webinar, where we're going to talk about record keeping and record retention policies. Companies do it differently. What we usually recommend is you have all of your employment documents related to them, all the new hire paperwork, performance appraisals, everything like that in the personnel file. You split out payroll into a payroll file. You always pull the I-9 forms and put them separate. And then usually you have a medical file. Some companies will put the health benefit information in with the medical. Sometimes you'll have separate documents or separate files for workers' comp injuries. Sometimes they're kept with the medical. So some of it is employer preference. But generally think about it this way, is in larger companies, if somebody's job bidding and another manager has the opportunity to come and pull that person's file and look through it to see if they want to hire that person or not, or allow them to transfer over, what information would they be legally entitled to see, and what should be kept private from them? That's sort of like the question I ask myself in terms of where we're going to put documentation. Marla, the question was about, are there any hard and fast rules about how to separate out employment documents, and should you have multiple files?
I agree with everything you just said. I was going to just point out the webinar as well because
Okay.
I did.
Well,
that was one that I mentioned, but I didn't mention some of the others, and it is on the PowerPoint presentation, I believe, the next page.
It's the next
you sent
slide.
everybody, correct, Joey?
Yep, and
Yes.
that's a great segue, and maybe you ladies could talk to our audience, because we're going to have to wrap up here, about what the upcoming webinar schedule is.
Yeah, so I think you just put it up on a slide. So next month we're actually going to talk about pre-employment assessments. You know, what's legal, what's not legal, talk about validations, and give you some ideas on some assessments you might want to incorporate into your hiring process. In April, as we just mentioned, it's going to be record keeping and record retention policies. So how do you set up files? Marla mentioned timekeeping. We could talk about that in there. And then, you know, like I-9 forms, you know, have to be kept for a certain length of time beyond employment, depending on how long someone's worked there, when can you shred them, that type of thing. May 22nd, back by popular demand, is going to be Lawrence Hartley with Oak Ridge Advisors. For those of you that heard Lawrence speak last year when we did a healthcare update, he was fabulous. This guy's so smart. He knows so much about the Affordable Care Act. So in May, he's going to sort of give us an update and let you know what you need to know for 2015. In June, we're going to be talking about exempt status with regard to who you need to pay overtime to and who you don't. And then in July, misclassifying 1099 independent contractors as employees, one of Marla's favorites. August, we're going to talk about background checks, and again, just some of the rules around that and what you want to do, because we have a lot of clients that ask about credit checks, background checks. I had a client who's a property management company and found out that one of their property managers was on the registered sex offenders list. You know, so like, what can you do about those type of situations that come up? September, we're going to talk about immigration, which is not a topic that Marla and I either one specialize in, so we're going to invite an immigration attorney that we know to be our expert speaker that month. October is going to be drug testing, and then in November, one of our favorites, and I think last year we had over 100 people on the webinar when we did this, was for disciplinary action and terminations and sort of our best practices around those issues.
Good. And again, ladies, you know, on behalf of all of us, we really want to thank you for your help. Linda Duffy with Ethos Human Capital Solutions and Marla Merhab Robinson with Merhab Robinson, Jackson, and Clarkson. Thank you again for joining us. I know Marla had offered the memo, I guess, on the 20, what was it again, Marla? The 20, hold on.
It's just a memo on independent contractors and the 20 tests. If anybody's interested, they can just email me and ask me for the memo. We'll send it out to you.
Okay, and we do have a few requests, so Marla can expect those to come. And again, we just went through the schedule for our next webinars. We're doing pre-employment assessments, which is always, to me, interesting, because I had no idea we couldn't do some of the stuff that we do. The legalities and the landmines you're going to want to avoid. So the registration link is there. It's going to be March 12th, 2014 at 11 o'clock. Again, we certainly appreciate your time, and we look forward to providing you with more useful information in the future. At any point in time you come up with a great webinar topic, feel free to email that to us, and we'll be happy to consider that in our schedule. Again, on behalf of Marla and Linda, thank you very much for joining us, and have a great day.